Ladies and gentlemen, welcome to Westminster Hall. For treason, the trial of the Magna Carta barons. Those processing in from your right are delegates from the Commonwealth Sergeants-at-Arms Conference. Please welcome them in the customary way.
England, 800 years ago. The year is 1215, the year of what is now called Magna Carta, perhaps the most famous document in constitutional history. It was on the 15th of June 1215 in the meadow of Runnymede between Windsor and Staines that the King sealed Magna Carta, Latin words which mean in English, Great Charter. It laid down a whole series of do's and don'ts for the King and his successors. Above all, Magna Carta asserted a fundamental principle, namely that the king was subject to the law. That principle has resonated down the ages and taken Magna Carta round the world. The Charter was appealed to by the parliamentary opposition to Charles I and by the founding fathers of the United States of America. It is still part of the political debate in Britain today. Tonight, we will explore the dilemmas and tensions which face some of the key players in this remarkable story. Our historical mock trial will, through testimony and questioning, seek to weigh up the rights and wrongs of some infamous characters. We will focus on the concept of kingship, hierarchy, and democracy, as historians suggest it was understood at the time, rather than how we understand them today. In 1215, King John would have fiercely denied both the need for the Charter and the legitimacy of the revolt against him. His rule had been conducted in accord with law and custom. King John's opponents took a very different view. They asserted that his financial exactions, his arbitrary treatment of individuals, his denial of justice, and his cruelty amounted to tyranny. The revolt against King John was led by Robert Fitzwalter. He was not alone. In Magna Carta, he was one of 25 barons empowered to force the king to keep its terms. King John, however, was not without support. He named 4 earls amongst his loyal councillors in Magna Carta. Here too, one name stands out, that of William Marshal, Earl of Pembroke. He refused to join the rebellion and acted as the king's intermediary with the rebel barons. The Archbishop of Canterbury was Stephen Langton, who had made his name as a professor of theology at the University of Paris, the capital of King John's greatest enemy, King Philip Augustus of France. King John had refused to accept him as archbishop until forced to do so in 1213 by an interdict imposed on England by Pope Innocent, shutting down churches. In 1215, Langton did not condone the revolt against the king, but, like Marshal, acted as an intermediary. To preserve Magna Carta was no easy task. The barons soon alleged that the king had issued it in bad faith and was refusing to implement some of its key terms. King John maintained that he'd been forced to seal it. Around the 20th of July 1215, the king sent envoys to the Pope asking him to quash Magna Carta. In mid-September, Robert Fitzwalter and his allies occupied the strategically important Rochester Castle in Kent. King John responded by ordering the seizure of Fitzwalter's lands. This is the moment at which the trial opens.
Court, all rise.
Very full court for a very historic trial. Usher, please bring up the defendants. Usher, please read the charges.
The barons are charged with treason against the king through their actions of sealing of the Magna Carta on the 15th of June of this year.
These are particularly serious charges. We understand that you have appointed Baron Fitzwalter to speak for you all. Baron Fitzwalter, do you understand these charges?
We understand the charges, but we challenge the procedures of this court. We feel we should be judged by our peers, which means our fellow barons, our social equals, not by judges appointed by King John, who really should be the person on trial. And we claim this under the terms of Magna Carta itself, its most famous chapter 39, which says that no free man should be proceeded against save by the lawful judgment of his peers or by the law of the land.
As justices of this court, we are your peers. In any event, the status of the Great Charter remains uncertain. My colleagues on the bench have travelled far to offer their wisdom and advice. We intend not only to allow both sides the opportunity to present their cases and call evidence, we will actually call two witnesses ourselves. So let us proceed. How do you plead?
Not guilty.
Do take your seats. Mr. Eady.
My lords, my lady, I represent the King, and I bring this prosecution by his authority and in his name. The defendants are represented by Natalie Leven QC. The charge is of treason, and the essence of that charge is disloyalty and betrayal. I will call only one witness, the King himself. His Majesty is not on trial here. However, he has graciously and exceptionally agreed to attend this court. He does so in order to assist you, his own judges, to arrive at the right answer in this case.
And when he is called, does he bow to us or we to him?
My lady, I suspect His Majesty might not take too kindly to a bow from himself alone. So might I suggest a bow on both sides, reflecting the mutual respect that each has for the other.
Very well.
My lords, my lady, the case for the Crown establishing treason has three strands. First, we say that Baron Fitzwalter and his conspirators have repeatedly set themselves against the King. Second, we say they have set themselves against the Church and His Holiness the Pope. The authority and commands of His Holiness the Pope, Innocent III, are of great importance to the issues in this trial, and that is because, as the court will be aware, 2 years ago, His Majesty placed this Kingdom of England and Ireland into the hands of Mother Church and became a papal vassal. In doing so, he subjected himself and all his subjects, including the barons, to His Holiness' protection, guidance, and ultimate authority. The evidence will show that His Holiness has condemned the rebellious actions of these barons and offered amicable resolution of their disputes, which was refused by the barons. That is sufficient for my purpose, but I also now, and very recently, have access to information not yet before the court of a most reliable kind, which enables me confidently to predict what the Pope's reaction will be to the King's requests to the Pope to annul the charter sealed at Runnymede.
My Lords, I object most strenuously to this submission. This evidence has not been disclosed either to the defence or to the court, and in my submission there can be no fair trial of my client unless this evidence is before the court.
What do you say to that, Mr. Neal?
My Lords, my Lady, for reasons of national security, which will need no explanation to my Lords and my Lady, to do with the protection of sources, I simply cannot reveal the nature of the source, but I would nevertheless wish to inform the court of this information on account of its thoroughgoing relevance to the issues in this trial.
Objection sustained.
My Lord, so be it. The third strand of treason upon which we rely is an unpardonable strand. The barons, we will say, and the evidence will bear this out, have allied themselves with foreign powers. This is now nothing less than an attempt to take the kingdom and hand it to our hated enemies, the French. We will, it appears, hear the treachery compounded with a series of scurrilous accusations of misconduct against the king. I say at once that they are without any evidential foundation, but I will also say that even if these allegations had a shred of evidential foundation, they would provide no justification for this treason, no justification in principle, and no justification in fact.
Thank you, Mr. Eady. Miss Leatham.
My Lords, my Lady, the defendants here have acted wholly in accordance with both constitutional convention and established precedent. The King's obligations under Magna Carta build upon the coronation oath of English kings going back to Edward the Confessor and King Edgar himself, and they also follow well-established European precedent in similar charters in France and Spain. As John of Salisbury put it, the tyrant is one who oppresses the people by violent domination. That is an apt description of John's conduct. He has murdered women and children, including the most horrific example of the de Brozes, who were forced into cannibalism by his actions.
My Lords, my Lady, I object to that. This is a scurrilous allegation without any evidential foundation whatever.
Overruled.
He's made huge financial demands upon the kingdom and ruled England simply for his personal gain. All these matters together, as you will hear, amount to tyranny. And my client's actions since the king sealed the charter have all been under the security clause or enforcement clause of the charter, which the king himself agreed to. So there is no treason here, and my client, Baron Fitzwalter, has been wholly justified in all his actions.
Thank you, Mrs. Levin. The court now calls Earl Marshal, the Earl of Pembroke. Could you please confirm your name and position?
I am William Marshal, Earl of Pembroke. I have served 4 kings, Henry II, his son Henry the Young King, Richard, Coeur de Lion, and our present King John, with absolute fidelity.
Well, what do you know about how this rebellion started?
Last summer, the king's allies were heavily defeated in a battle in France at a place called Bouvines. In October last year, they swore at Bury St. Edmunds that they would arm themselves.
Well, then how did the negotiations with the barons proceed?
it was agreed that the barons and the king would meet after Christmas for a discussion of their demands. The rebel barons came to that meeting, but they were armed as if for battle. Faced with this threat, the king decided that he would not negotiate.
So what next?
Well, then negotiations were renewed. I guaranteed the safety of the rebels at those negotiations, and in the meantime, both the king and the rebel barons invited the Pope for his decision on the discord between them. In March 1215, the Pope ordered the king to give proper consideration to the demands of the rebel barons, but he also ordered them not to make war on the king. Their response was to gather an army together at Stamford, and for this reason the king did not attend the meeting that had earlier been fixed to take place in Northampton.
So we get now to May 1215.
The Archbishop of Canterbury and I went to Brackley to act as intermediaries on behalf of the king. On the 5th of May, the barons publicly repudiated their oaths of homage to the king. His offer of negotiation was rejected. The barons laid armed siege to the royal castle at Northampton.
And next?
Then the king made a formal offer of arbitration in an attempt to avoid civil war. He proposed 8 barons, 4 to represent him and 4 to represent the rebels chosen by them, with the Pope as the final arbiter. And he promised that while such a negotiation was continuing, he would not take any steps against the rebel barons.
So what was the barons' reaction? Did they take up this offer of arbitration?
No. The barons marched on London. On 17th May, led by Robert Fitzwalter, they entered London. The city fathers gave them an open entry, and there they attacked the tower.
Well, what was the king's position?
Hopeless. He was deserted by many of his former supporters, including his half-brother. He was obliged to negotiate and find a way of making peace. The alternative was civil war. I was present throughout the negotiations at Runnymede. The charter was drawn up. A group of 25 barons were entitled to enforce its terms.
That was Clause 61, the so-called security clause, which purported to empower the 25 barons to seize the king's castles, lands, and possessions. Now, what was your view of that?
It was contrary to their oaths of fealty. It was inconsistent with the basic structures and hierarchies of our kingdom. It ignored the fact of kingship. It ignored the fact that the Pope was the king's feudal lord. It represented pre-authorized rebellion.
Do you consider that that was freely agreed to by the king?
No. He had no choice.
So, what then?
Well, after the charter was sealed, oaths were taken, and peace was declared, and the king disbanded his small force of foreign mercenaries.
So that was the end of it, was it? Did the barons go peacefully home?
I'm afraid not. I do not believe they ever disbanded any part of their army. Certainly, they did not hand London over to the king or allow him to receive his revenues from London. Open rebellion persists now, and Rochester Castle has been occupied.
Well, finally, have the barons acted alone?
I believe that they have offered the crown of England to Louis, the king, the son of the King of France. I myself have been invited to a meeting of all the chief men of the kingdom. The business of the meeting, I believe, is to replace the king with Louis of France and to crown Louis at Westminster Abbey in rebel-held London. I am also aware that overtures for assistance to the rebel cause have been made by the rebels to Llewellyn of Wales and Alexander of Scotland.
Thank you, Earl Marshal.
Ms. Lever.
Earl Marshal, can I just start by clearly understanding your position? You support the principles set out in Magna Carta, save for the so-called security clause.
Yes, I do. It includes some very valuable principles relating to the administration of justice, and it limits the power of the king to raise taxes without the consent of the Common Council of the realm. So, yes.
So how do you suggest that King John, given his past conduct and his complete untrustworthiness, can be made to abide by the terms of the Charter?
I don't know. But like so many kings, including his father, and many kings before him, he has not abided by the terms of his coronation oath. Some years ago, he regarded me as a traitor. I had no trial. I was sent into exile for many years. 2 of my sons were taken by him as hostages. But much more seriously, when I heard of the death of Matilda de Broas and her son, which was an awful incident, I reflected that this king's father had murdered an archbishop in his own cathedral. They will both have to account to God.
But with respect, Earl Marshal, that is not answering my question. Without the security clause, how can the king ever be made to keep his word?
The security clause is unenforceable. It's meaningless. It can only take effect while the king remains weak. If he ceases to be weak, it has no force. Until he is able to address it, it means that instead of 1 king, we shall have 25. At the same time, loyal barons like me owe no fealty to any one of them, and they owe no fealty to each other. If negotiations fail, the remedy is to refuse to pay taxes. That is what I did when an unlawful application was made for me to pay tax. That was why the king called me a traitor. That is why I went into exile. But the reality is the king cannot live off his own lands and assets any longer. And so in reality, as well as the important terms of the Charter, he cannot collect taxes which are going to be raised without the consent of the Common Council.
So I would suggest to you that that answer simply shows the necessity of the Charter between king and barons, and the justification for the defendants in forcing the king to enter into it.
Well, you may make that suggestion, but it's for the court to decide whether it's sound or not.
Earl Marshal, you may take your seat.
Thank you very much.
Mr. Eadie.
I now call the king. You are John, King of England?
I am. I am, by the grace of God, King of England, Lord of Ireland, Duke of Normandy and Aquitaine, and Count of Anjou.
Yes.
Crusader, and loyal vassal of His Holiness the Pope.
Thank you, Your Majesty. You've graciously agreed to appear before this court to assist it in its task, I think.
Indeed I have. These are my judges, this is my court, and I know that you will be applying the laws and customs of England. I support the law. I have nothing to fear from the law itself. And in coming before the law, I do so willingly, trusting in God that the judges, my judges, will come to the right decision. I'll be fair and tell all I know about this rebellious man and his fellow conspirators. I am the king. I make no apology for, on occasion, taking difficult decisions and being ruthless with my enemies. My enemies and the enemies of England. These men have made themselves my enemies. They are the very men who plotted to assassinate me 3 years ago. They should be helping me as we support our troops, regrouping after the French brutally resisted our attempts to retake across the Channel what is rightfully ours.
Your Majesty, yes. And what have they actually done, these barons?
What have they done?
What have they done?
They have renounced their oaths of homage and loyalty. They were in open and armed rebellion. They remain in open and armed rebellion. They have taken my capital city against me. They're in league with my sworn enemy, the King of France, and the King of Scotland, and the Prince or Princeling of Wales. They desire nothing more or less than to take my kingdom away from me.
But you have...
It's an obvious case. An obvious case of treachery, lèse-majesty, sedition. It's an open and shut case. I think we all agree.
Your Majesty, but you have conducted negotiations with them. You sealed the charter at Runnymede. Was that freely done?
Well, of course it wasn't freely done. They forced me to do it. They forced me at sword point. By these rebels, I was forced to do it. I believe you have evidence on this already. It's not in any doubt.
Your Majesty, why do you think they forced you to seal this charter?
Well, they are obviously only interested in themselves. There's a lot of high-blown language, but it's all for their own benefit. They secured a series of concessions to suit their own purposes. They demanded provisions to drastically cut my ability to raise taxes, to defend our shores. They wanted to deport my most loyal constables. They damaged my ability to even administer the kingdom, to build bridges, to secure rivers. Extraordinary amount of damage. They included a sting in the tail of the charter, the so-called security clause. It provides that 25 of their number may distress and distrain me in every way, taking mainly by seizing castles, lands, and possessions. Now, would I have sanctioned such a process if I weren't forced into it? Quite obviously not. Never. This is consistent. It's not consistent with the bonds of loyalty that bind us to Rome. It certainly is not. The piece of parchment that is under discussion here is nothing short of a national disgrace. It cannot stand, and I have asked the Pope to annul it, and I have confidently expect that he's going to do so.
They say, Your Majesty, the barons, that their cause was just, and that they had no option. What do you say to that?
Well, is there a justification for acts of gross rebellion? I don't agree. The calumnies whispered against me are just that, lies and falsehoods. What I have done, I've done in proper exercise of my sovereign authority. They claim they have grievances, I deny them, but when they mention them, when they bring them to me, I listen to them and I discuss with them.
You were willing to listen how, Your Majesty?
Certainly, I offered to negotiate. I believe you may have evidence on this already. I offered them arbitration subject to the proper ultimate authority of His Holiness the Pope. Now, what could be wrong with that? But that wasn't good enough for them either. You've heard the evidence, I believe, of the Earl of Pembroke, but their demands are outrageous. The path of peace has been rejected by them time and again in favour of armed rebellion and naked treachery.
Your Majesty, thank you. If you wait there, my learned friend might have some questions for you if she's bold enough.
Your learned friend.
Your Majesty, you murdered Arthur of Brittany when a child, and you ordered the death by starvation of Matilda de Bresse and her son. If you deny these charges, where are those people?
If you have evidence of this, bring the evidence forth. Bring forth the bodies. I'm not accepting any of your calumnies now.
Your crimes are almost endless. You have seduced by force the wives and daughters of many of the barons, including my own client's wife. The wife of one of the barons, de Vesci, only escaped from your attacks by smuggling a prostitute into your bed instead.
Madam Advocate, I despair that you reduce to such tittle-tattle and mere gossip, and, if I may say so, using a legal term, hearsay. Have I been a more brutal king than William I, the Conqueror? Have I had more women than Henry I? Have I done anything that hasn't befit? This is mere pretext to challenge my authority. This could be used to challenge anybody, any king's authority throughout the ages.
But what you have been, Your Majesty, is a much worse king, because you have acted to ruin not just my clients, but this country. You've charged exorbitant taxes. You've forced numerous widows to pay huge sums not to be compelled to be remarried. You've imposed a massive tax of over 100,000 marks on the country, which has impoverished every person in this kingdom. And all of this, not for the good of the country, as perhaps William I did, but simply for your benefit in fighting foreign wars.
And what is your question, Madam Advocate?
Do you accept you
I
have
do
done
not
all
accept
those
this.
things?
I had to raise money. I'm at war with my enemies abroad. These barons, these rebels, should be supporting me and our loyal troops, my loyal troops. They're trying to cut me off from the revenues that I should properly be raising so that I can finance these expeditions which are necessary for me, for our country, and for England.
And what is more, Your Majesty, which may have more resonance to some in this audience, is that you have reduced justice in this country to a farce. You have charged huge sums for people to gain access to the courts.
Sometimes that is necessary, as people find through the ages. In any case, I deny that my demands have broken law and custom. What this charter asserts as ancient rights are outrageous novelties. Charges have been made. What these barons want are not justice, but victories over their opponents. So, if they wish to bring cases to court, then it's perfectly within my rights to charge them for it, so I may finance the proper business of the kingdom out of the proper revenues arising from cases in my law courts.
And finally, Your Majesty, you have deprived your subjects, including many of my clients, of their property with no lawful process. What I would suggest to you is that the only way to stop these abuses is through the mechanism of Magna Carta.
I reject this attempt that you're making to throw mud at me and to rake up any minor complaint that can be dredged up against me. I deny that these are all pretexts which have been used. I had to decisively put down dissent. By God's teeth, if I had not done this, I would be no king at all. I would be toothless itself. There is a plot here to kill me, to take my capital, to take my kingdom, and replace me with the King of France or his son. If that isn't a clear case of treason, then what could be?
Thank you, Your Majesty.
Thank you.
Thank you, Your Majesty. You may now take your throne.
Thank you, Your Lordship. My Lordship.
Now for the defence case. Miss Lehman.
I call Baron Fitzwalter, leader of the barons. Could you start, please, by confirming your name?
Yes, I'm Robert Fitzwalter, Lord of Dunmow in Essex, and of Baynard Castle here in the City of London, a loyal Baron of England.
Now, can I start by putting to you directly, have your efforts to persuade the King to seal the Great Charter merely arisen out of self-interest?
What nonsense, absolutely not. I'm the reverse of the big, bold, brutal Baron of my enemy's caricature. I thought deeply about the distinction between just rule and tyranny, about the King's obligation to govern for the benefit of all his subjects, not just for himself. And you can see that from the tracts written by my associates in London. Now, judged by these standards, John is absolutely convicted of tyranny of the worst kind. And we barons, representing the community of the realm, have a duty to place restraints upon him.
But do you also have your own grievances?
Well, sure, yeah, I've got my own grievances, that's perfectly true, and they mirror the grievances of so many others, making Magna Carta all the more necessary. John has indeed sought to seduce my wife. He has denied me possession of my wife's inheritance of Hertford Castle. It's only with Magna Carta that I've recovered Hertford Castle under its terms, and John has acknowledged that he'd acted lawlessly and by will against me.
And were your actions in 1215 in breach of your oath of fealty to the king, as the prosecution suggests?
This is another one of these gross calumnies. We followed the absolute, formal, long-standing procedure of formally renouncing our homage to the king. And that severed the bonds between us. And that John actually acknowledged that is shown by the fact that we had to renew our homages on the 19th of June at Runnymede. You admitted that the bonds had been severed. Therefore, we cannot be accused of treason.
Silence in court.
And lastly, the prosecution say that you have disobeyed the will of the Pope.
Well, I'm sorry about that, but Archbishop Langton, he is Primate of all England, he is a cardinal of the Holy Roman Church. I mean, I take the Pope's views from him, and Archbishop Langton has not in any way excommunicated us. What more can I say to that?
Thank you, Baron. Mr. Eady may have some questions for you.
Who is John?
That man there.
You give Archbishop Langton his proper title, but decline to do so for your lawful king.
Well, I'm pleased to say we're in the process of deposing him. The kingdom is in the process of deposing him for his gross tyranny and breaches of Magna Carta.
You have form, Baron, don't you?
What do you mean by that?
In 1212, you were involved in a plot to kill the king with your co-conspirator, Eustace de Vesci.
Master Eady, you shouldn't believe everything you're told. It was a plot to depose the king, not to kill him. And it was also undertaken precisely as the Pope and Archbishop Langton wished, because we were defending the kingdom from an excommunicated and tyrannical king.
A plot to depose, then, not to kill.
Exactly.
That's the distinction on which you found, is it?
It's an important distinction, and also, by deposing him, we were saving the kingdom from this excommunicate down there, and from someone who's practiced tyranny on an unheard of scale.
You were outlawed, were you not, on grounds of treachery in the shire courts? You had the wolf's head placed upon you.
That's another one of these cases, Master Eady, where you seem to be falling for the propaganda of King John himself. It's completely untrue. I was outlawed by his order, clean contrary to the custom of the land, and Magna Carta itself was designed to put a stop to that kind of procedure.
And then decided to run to the court of King Philip of France.
Well, what else do you expect me to do?
Baron, in January of this year, following the defeat of the king's allies at Bouvines, you saw your chance, did you not, with the other barons, to take advantage, to force him into concessions.
I saw the chance, my fellow barons saw the chance of rescuing the kingdom from this man.
What is a conjuratio?
It's an association to achieve some purpose bound together by oath.
In other words, a plot.
Well, you can call it that if you like.
Ever entered into one of them?
I'm proud to say so.
Against the king?
I'm proud to say so, or the person who once was king and will soon be no longer king, thank heavens.
You entered into that with the barons, including de Vesci.
De Vesci is a great and good man.
Is it true that on the 5th of May you repudiated your oaths of homage to the king?
Absolutely true, and for good reason.
Yet His Holiness the Pope disagreed in the strongest terms with that plea of justification, didn't he? In his letter of the 18th of June, he condemned you for that very act of repudiating your oath and directed Archbishop Langton to place your lands under interdict.
I'm afraid that letter of 18th of June, Master Eady, on which you seem to rely again and again, merely shows how out of touch the Pope was with events in England. It didn't arrive until a month after Magna Carta. Archbishop Langton himself, a far better judge of the true situation in England, never excommunicated us under the terms of any papal letter.
Baron, you could have avoided all of this armed rebellion, all of this bloodshed, could you not?
Are you talking about the bogus offers of arbitration advanced by King John.
We've heard from Earl Marshal of the various attempts to sort out the grievances, including arbitration with 4 barons on each side under the auspices of His Holiness the Pope, and yet you choose to pursue armed rebellion over peaceful resolution. Is that fair?
Well, you've said these offers of arbitration were under the auspices of the Pope, too right. And we knew what to expect from that, given the way John had misled the Pope. I might also inform you that these offers of arbitration were always subject to one very important qualification, namely that while the arbitration was going on, John should be able to exact all our debts. So by the time the arbitrations were over, we would have been ruined. They were totally bogus, these offers of arbitration.
Baron, at the head of this armed rebellion stood you, and you had awarded yourself a title, I believe. What was it?
Marshal of the Army of God and Protector of the Holy... Just let me finish. Marshal of the Army of God and Protector of the Holy Church.
That was the Army of God challenging the King's authority and peace, was it?
It was the Army of God rescuing England from a tyrant.
By whose authority was that title awarded? His Holiness the Pope, I assume.
I'm proud to say it was awarded to me by my fellow barons and by many distinguished churchmen.
By your fellow conspirators, in other words.
Well, you can put it like that if you wish to demean what was actually a noble effort to rid the king, to rid England of this tyranny.
Can we move to the signing or the sealing of the charter?
Do get it right, please. It was sealed, not signed.
I stand entirely corrected. You forced the king to seal the charter, did you not? At sword point, as the very first clause of the charter acknowledges.
Well, I think you've misunderstood the first clause of the charter, if I might say, Master Eady, but that too is a falsification. It's perfectly true that some degree of force was needed, and you can quite see from the performance of that man up here why. But it's wrong to think that he was forced to accede to the charter by sword point. When he acceded to the charter, when he sealed the charter, his armies were still intact. He had not lost a single castle. He entered into the bargain completely freely.
Would you accept this, that Clause 61, the so-called security clause, is the clearest possible indication of how you see your role, a committee of self-appointed, self-interested guardians between God and the King? Is that a fair characterization?
I like the way you say guardians. Yes, guardians of the kingdom against the king. And you've seen the performance of that person up here. Would you have trusted him without some device like the security clause? As it was, the security clause was a very moderated document. He has 40 days to put right any breach of the charter. It's not the sort of sledgehammer which it has been portrayed as.
You re-swore your oaths of loyalty and homage after the charter was sealed.
Well, can I first of all just say, before we get there, that this idea, this portrayal of Magna Carta as a selfish baronial document is a complete travesty of the truth. It protects the whole kingdom from tyrannical rule. I prophesy that the Pope himself in due time will confirm it, and that future generations will treasure our work.
Baron, you're here to answer questions, not to make speeches. Mr. Eady.
The question, Baron, was whether or not you re-swore your oaths of homage and fealty to the King.
We did.
And yet you have continued to wage war. You are still in open and armed rebellion. You have refused to hand over London, and only last week you occupied Rochester Castle by force of arms.
Absolutely right. And all those things were completely justified by the security clause itself, because John had failed to implement key sections of the charter, and it became absolutely clear that he had issued it in bad faith, and he was now reneging on the bargain altogether and was appealing to the Pope, as he himself said. He was appealing to the Pope to have the charter abrogated. What do you expect us to do?
One last question, Baron. Are you now plotting with Philip of France? Have you invited him to invade, and do you plan to put his son Louis on the throne of England?
Most certainly we do. and we expect a far more benevolent king from the Capetian kings of France, who have none of this evil reputation of the Angevin dynasty. And in deposing King John, we are following, again, long-standing customary procedure of withdrawing our allegiance from one of the most evil kings who has ever sat on the English throne.
That is enough. Thank you, Baron.
You may take your seat, Baron Fitzwalter. The court now calls His Grace the Archbishop of Canterbury. Archbishop, will you please state your name and tell us of your role in these matters?
I am Stephen, by the grace of God, Cardinal, Primate of England, and Lord Archbishop of Canterbury. As to my role, I have always sought the safety and tranquility of the realm and the security and dignity of the Church. I am the King's servant, but I am God's servant first, just as His Majesty is.
Now, you say that you are the King's servant, but you studied and taught for 20 years in the capital of the King of France, King John's enemy.
Well, that's quite true, but I am a proud Englishman, born at Langton in Lincolnshire, and it is to this realm that I owe my loyalty.
You were appointed Archbishop of Canterbury in 1207. What happened then?
Following my election, my lawful election, the King seized the lands belonging to Canterbury, expelled from England the monks who had elected me, and refused me entry to the kingdom. When the Holy Father then placed England under an interdict in 1208, the King confiscated the lands and property of the Church and diverted all the Church's revenues into his own coffers. In the period of arbitrary and oppressive rule that followed, of a character, I may say, never before seen in this land, was it surprising that 4 years ago, while the King was still excommunicate, I urged the knights to defend the realm with their swords and said that the King's subjects would be absolved from their fealty if he persisted in his disobedience.
When did this period you describe end?
Well, 2 years ago, His Majesty accepted my appointment. I was at last able to come to England as Archbishop, and I absolved the King from excommunication, and he swore to abolish evil customs, judge justly, and uphold the laws of his ancestors in protecting the rights of his subjects.
Well, the court will decide whether the King has done so, but what has been your role in recent months?
I have always sought peace, and I agreed with William Marshall on the 27th of April to take the barons' demands to the King. The barons, of course, hoped that I would declare for their side. But if I did so, how could I then be a peacemaker? I support the Charter. I believe in royal power to protect the Church and also to give peace to the people. But in my teachings on the Bible, and especially on Deuteronomy, I note the limits on royal power, for the law is for the king as well as for the people.
Mr. Eadie, do you have any cross-examination?
My lady, I do, with your permission. Archbishop, first, if I may, the relationships within the Church and between the Church and the barons. The spiritual lord is the Pope.
Yes, he is.
The Church is built on a hierarchy of obedience. Do you accept that?
It is, certainly.
And the Pope is at the top of that hierarchy.
Yes, indeed.
So you and your bishops through you are spiritually obliged to do his will, to act in obedience to his commands, and to accept his rulings on issues of controversy within his sphere. Is that right?
Yes, but it is also my duty to make the Holy Father aware of all the facts of a case, to assist him in making those rulings.
On that basis, my lords and my lady, with your permission, can I hand up a letter from the Pope, dated the 18th of June 1215, sent when he was informed of the renunciation of their oaths by the barons. And whilst that is being handed up, and to put this June letter in context, Archbishop, you had already received, had you not, in March from His Holiness, a letter in which he, and I quote, utterly condemns those who have dared to form leagues or conspiracies against the king.
Yes, I recall that letter.
He's referring to the barons, is he not?
I take it that he is, yes.
And you accept that this letter of June, I believe you have a copy, you accept that this letter of June makes clear the Pope's view, that that was utterly unacceptable.
Well, that's perfectly clear from the letter.
Would you read the first highlighted section for me?
Certainly. Those men are undoubtedly worse than the Saracens, for they are trying to depose a king who it was particularly hoped would succour that holy land.
Those men are the barons?
Yep, yes.
Would you read the next highlighted section?
Certainly. We would not leave such great wickedness unrebuked, for by God's grace we know how to punish, and we are able to punish, such shameless presumption.
So, reflecting those views, the Pope directed you and your bishops to condemn Baron Fitzwalter and his rebels and place their lands under interdict. Is that right?
Yes.
You didn't do that, did you?
No, I didn't.
That was straightforward disobedience and broke all your vows of obedience, did it not?
I think Council needs to get real about this. You must remember that letters take some considerable time to arrive from Rome. And had the Holy Father known how dangerous the situation was and how close we were to open war, I don't think he would have asked me to take that action. Matters had gone much too far, and we were on the brink of civil war. Excommunicating the barons would have made that war absolutely certain.
Archbishop, you were suspended from office by His Holiness the Pope for precisely not implementing the papal sentences of June, correct?
Yes, I was.
And then on the 7th of July, 1215, His Holiness the Pope had himself to declare excommunicate all disturbers of the king and kingdom along with their accomplices and supporters.
Yes.
And it's quite clear that he is referring to the barons.
I take it that he is, yes. But I would also say they were not the only ones disturbing the kingdom. When I lifted the king's excommunication 2 years ago, he renewed his coronation oath to abolish evil customs and to judge justly. I'm sorry to say that he's broken that oath many times, and I count him by those actions a disturber of the kingdom.
But not the barons?
I am even-handed on this, as I've made clear. Throughout my evidence, I sought peace, and that peace was the baron's responsibility, but it was also the king's responsibility.
I think we can agree on that, Archbishop. You wanted peaceful resolution.
Yes, I've said so many times.
And that is the course that His Holiness the Pope wished also, as he made clear in his letter of March this year.
Yes, that's correct.
And you accept, do you not, that the offer of arbitration was an obviously appropriate dispute resolution mechanism?
Yes, I do.
And you recognize the authority of the Curia in Rome to resolve such issues?
Naturally.
And you also recognize that the offer of arbitration included an equal number of barons on each side?
Yes, I do.
Would it be fair to say that your view is that it was highly unfortunate that that course was not taken? Would that fairly reflect your view?
More than that, it was not only unfortunate, it was tragic that that course was not taken. But I firmly believe the deep distrust of the king meant that it was never a practical possibility.
Finally, Archbishop, to move from the spiritual to the temporal, Rochester Castle. Would you accept that Rochester is a vital fortress to the defence of the realm?
My advisors tell me that it is, yes.
It is a castle returned to you when the interdict was lifted, is that right?
Yes, and as part of the reparations to the church for the illegal seizure of church property by the king.
And yet you have refused, despite a specific request from the king, to surrender Rochester Castle to him.
Yes, certainly I did. This was a property freely returned to the church by the king. Now it appears that he wants to go back on his word. Well, I will hand it back, but only if commanded to do so by a legal judgment.
The king has written that you have become, and I quote, a notorious and barefaced traitor to us, since you did not surrender Rochester to us in our great need. Do you agree with that assessment?
Well, he would say that, wouldn't he?
Thank you.
But for the reasons I haven't finished yet, but for the reasons I have given, emphatically, I do not agree.
Thank you, Archbishop.
Thank you, Archbishop. You can take your seat again. Well, it's time for closing speeches. Mr. Eadie, for the prosecution.
My lords, my lady, I dealt with treason in opening. It is, we suggest, clear and uncontestable. The barons have set themselves against the king, they have set themselves against the Pope, they have done so repeatedly in open and armed rebellion in breach of their oaths. They have played the game of politics, they have done so for the highest possible stakes, and they have lost. Is the treason justified? As his judges, I know that you will take the greatest persuasion and the clearest possible evidence before even contemplating a finding that His Majesty's conduct had become tyrannical. There is no such evidence, not a shred of it, and I emphasize again, the King is not on trial here. In any event, even if there was such evidence, we say that there are 5 core answers to this spurious plea of justification. Firstly, the defence is unavailable in principle. There is no justification for the barons raising arms against the king. There might be a philosophical question as to who it should be who could control the king, if not the barons. The answer to that philosophical question would be either God or His Holiness the Pope. For the purposes of these charges, it matters not which is the correct answer, because the important point is that it is on no view the barons. Secondly, on the facts, you've heard the evidence. They could have avoided conflict and rebellion. They chose to take up arms instead, and there is no justification for that. We are dealing here with a shattering of the peace, affecting the realm, and they need to justify upsetting the fundamental orders and structures of society. The principle governing when, if at all, that is permissible must recognize that. Even if it can be legitimately disturbed, it can only be disturbed, we submit, A, as a matter of extreme last resort, and B, to the absolute minimum amount required. A principle of proportion, or even proportionality, it might be thought, is one that has some legs to develop. Here, as we have heard, they have plainly breached it. They rejected arbitration. They were offered the perfect opportunity of submitting the disputes, the political disputes of the day, to an international tribunal sitting in Europe. And that, as you have heard, is an eminently sensible way of dealing with such disputes. They decided instead to pick up arms and fight. Thirdly, any legitimate complaints they may have had can provide no justification whatever for going into league with the French, the Welsh, and the Scots, the latter two perhaps emphasizing the dangers of having independent states within these islands. Fourthly, they were not acting in anything other than blatant self-interest. It was on no view a desire to help the common man or to establish the rule of law that drove this rebellion. It may be that at some future point, lands far to the south or to the west of here will be discovered, and that some principles of the Charter will resonate with them, even perhaps to the point of erecting monuments in Runnymede. And it may be that clauses 39 and 40 will come to inspire the foundations across the world of constitutional settlements in which every subject is protected by the rule of law. But all of that would require sorcery to predict, and idle speculation. It can provide no answer to this charge. If the Charter is the yardstick for the justification defence, its true nature needs to be recognised. It represents little more than a collection of measures that serve and are designed to serve the narrow interests of the barons. Finally, there is nothing in the suggestion, and this is the fifth point, that the so-called security clause justified their conduct after the Charter was sealed. That clause, like the rest, was obtained under duress. It is void for that reason and should not be recognised by this court. Earl Marshall had it right. It would have amounted to pre-authorised rebellion, his words. It provides no veneer of legality for armed rebellion and conspiracy with England's enemies. There is no justification for this rebellion. That is the view of His Majesty the King. It is the view of His Holiness the Pope, by whose hands these defendants stand before you, excommunicate. Treason is charged. We invite you to find that treason is established.
Hear, hear.
Thank you, Mr. Eady. Ms. Leaven.
My lords, my lady, there are three grounds of defence here. First, there is no treason. The laws of England are clear. A vassal, as my client has explained in the witness box, is entitled, if he has suffered grievous wrong, to renounce his homage and allegiance to his lord by an act of defiance, diffidatio. The bonds between them are dissolved, and the vassal can then act freely against his former lord. That is what the king accepted at Runnymede when he had the barons renew their homage. Second, justification. It can hardly be doubted that the barons had suffered grievous wrongs, as had the country. Those wrongs were deeply personal. You've heard Baron Fitzwalter's evidence about the attack on his daughter and on the wives and daughters of other barons. They were wholly unlawful actions by the king in extracting massive and unjustified fines, selling justice for his own benefit, and the arbitrary and wholly unlawful seizing of property. And the king had simply become a tyrant. He will go down in history as possibly the worst monarch that England has ever had to endure. So in those circumstances, the barons were not just justified in acting, they had to act. As Bracton said, they had to put a bridle on him. And it was not open to them to sit and wait for God or even the Pope to intervene, to order the king to act. If they had waited, this country would have descended into chaos. Magna Carta is a document which protects the whole country against arbitrary and tyrannical rule. It sets a framework for a just and balanced set of rights and responsibilities between ruler and subject. Let me give the court a few examples. Chapter 60, which requires that all the king's concessions be passed down from the barons to their own men. Perhaps most importantly for future generations, chapters 39 and 40, which require the rule of law as laid down in Magna Carta to be applied to all free men. And equally importantly, the liberties of London being secured for the long-term economic good of this great city and this country. None of that would have happened without my clients requiring the clauses in Magna Carta. And equally importantly in history, the court may find the clauses that demand that the king can only require taxation with the consent of the Council of the Realm. These rights apply to all free men, and they secure good government for everyone in the country, including serfs and even women. To suggest that the barons are merely self-serving because some of the rights in Magna Carta do not apply to the unfree is a bit like saying that the Athenians weren't democrats because slaves and women couldn't vote. Baron Fitzwalter and the other barons have acted to ensure peace and good government throughout the kingdom and to stop a tyrannical king from bankrupting England and reducing it to anarchy. The prosecution, and indeed His Majesty, complain of the security clause, but as the court and many others will know, no agreement is worth the paper it's written on if it doesn't have an enforcement mechanism. And this king has shown, through his evidence to this court and his actions, that he is so untrustworthy that no sensible man would enter into agreement with him without such a clause. Indeed, it is the king's untrustworthiness and his failure to abide by the terms of the Charter that have left my clients with no choice but to approach the French to restore some notion of justice and good government to this country. And thirdly, the real question for this court is, were my clients justified in persuading John to enter into the Charter? And to that question, there can only be one answer. Even if the barons were technically guilty of treason, their actions will be proved by history to have been justified and indeed essential. They put their lives, their families, and their possessions at risk for the good of the kingdom. And history will show that the balance in Magna Carta is one that most, or nearly all, subsequent kings will have no difficulty abiding with. And that is because it is a fair balance. If the court rules against my client, then the court will be finding that tyranny must go unchecked and that kings are not subject to the rule of law. If this court were to come to that conclusion, it would send an appalling message around the known and indeed unknown world, and it would set a precedent for tyranny and undermine the role of justice for centuries to come.
Thank you, Mr. Eady. Thank you, Miss Leven. We shall retire briefly in order to consider our verdict.
Court, all rise.
Defendants, please stand. Fitzwalter, chief among you. We have considered the evidence. Would you please stand? We have considered the evidence before us, and I would like first to invite Dame Sian Elias to give her opinion.
The question for the court is whether Baron Fitzwalter and the other barons are guilty of treason as charged. That must be decided on the evidence we have heard and after applying the law of the land. That's our province as judges, which is why the opinion of His Holiness on the validity of the Charter is not relevant to our task. There are two principal arguments put forward by the prosecution. First, it is said that the Charter was extracted by force and is void for duress, so that its non-observance by the king is no justification for the latest resort to arms. Secondly, it is said that the barons had no justification for renouncing their oaths of fealty and taking up arms against the king in the first place. The king, it is said, is accountable only to God. In my view, the contention that the Charter is void for duress fails on the facts established by the evidence and on the terms of the Charter. First, John came out from his stronghold at Windsor Castle to negotiate the Charter. He was attended at Runnymede by a powerful force, including the greatest knight in England, William Marshal. It was John who gave safe conduct to the barons. Archbishop Langton, who was in a position to know, refused to excommunicate the barons, as he would surely have done if the Charter had been coerced. The Charter was not extracted from King John at sword's point, as the king suggested in his evidence. Secondly, by the Charter, John gained some important advantages, not only peace, but even through the Article 61 he disparages, Chapter 61, which he disparages, significant gains. By Chapter 61, the barons promised to return to obedience when reparations as agreed had been made. In the meantime, the safety of the king and his family were secure. The terms of the Charter do not, then, support the contention of duress. Now, even if there was no duress, were the actions of the barons treason? This turns on whether the barons were entitled to insist on the king's observance of his obligations and entitled to renounce their fealty until he returned to his duty. There are 4 points. First, fealty is reciprocal, as the act of homage makes clear. John's breaches of duty justified those he had wronged withdrawing their oaths of fealty. They were entitled to take up arms to compel the king to return to his duty, as William Marshal had earlier been justified in defying the king when he was himself wronged. Resorting to self-help in this manner is not treason in 1215. The fact that homage was renewed following the Charter shows, as Baron Fitzwalter rightly said in evidence, that the bonds of fealty had earlier been dissolved on 5 May by the formal act of defiance, diffidatio. Second, as to justification for the act of defiance, the evidence of actions taken by the king against the laws and customs of England is overwhelming. The king is not above the law. Glanville and Bracton make that clear. And in any event, limits follow from the very concept of freedom. The unfree may be subject to arbitrary government by those in authority over them, but a free man is protected against arbitrary interference. Wherever power is organised and not arbitrary, it is subject to law. That includes the power of the ultimate temporal lord, the king. The king is made by the law and is subject to the law. Thirdly, the prosecution puts forward a novel proposition for which there is as yet no support in our law, in arguing that the defence of justification can never be available against a king and that the king is answerable only to God. If accepted, this divine right to arbitrary sovereign power, unlimited by law, would deny constitutional government. It is contrary to our traditions and should not be accepted in our time. If it takes hold, it is bound to cause a great deal of trouble and may even lead to revolution here or in overseas territories we may have in the future. We should not go down that path. Lastly, the acknowledgements made in the Charter are not novel. There are precedents for them in the coronation oaths, in the Charter of Henry I, and as a matter of comparative law in European charters. The comparative law dimension indicates that the themes expressed in the Charter are universal, not outrageous novelties, as the King would have it. The Charter is an insecure step only, but the ideas it contains tap into fundamental human concerns with justice, fairness, and good government. They can be expected to develop. For these reasons, I would find the accused not guilty.
Thank you. Justice Breyer.
Well, I agree with my colleague, and I will, in fact, just limit what I'm going to say to one part of the treason charge, but what was at the heart of what they were saying, charging the barons with treason in forcing King John to sign the document. I'll assume it was forced. I'll assume that. But this is a criminal case, and it has to be clear that in forcing him to sign it, they are committing treason. Now, I think that the governing law, which is important to keep in mind, is something that Bracton said. It's famous for its requotation later, but Bracton said this about the laws of England in 1230 or 1240, right around this time. It's famous because Edward Coke later quoted it to James I, and it was very brave to do so. That was many years later. Now, the key sentence, I think, is this. Bracton says, thinking of this time, the 13th century and earlier, the laws and customs of England, the king must not be under man, but under God and the law. For the law makes him king. Therefore, the king attributes to the law what the law attributes to him, namely domination and power. For he is not king where the will controls and not the laws. At a later time, it became famous in schools' examinations to quote King Bomba of Naples, who said, "I am the king, and I will have dumplings." That is an instance of will. It is not an instance of law. And there is no obligation to support the king in such a matter. Now, let us go back and see what the Charter actually holds. Well, there are many things in it. But the part that has become famous, that we consider to be at the heart of this, is the sentence in 39. No free man shall be taken, imprisoned, seized, outlawed, banished, or in any way destroyed, nor will we proceed against or prosecute him, except by the lawful judgment of his peers and by the law of the land. They're making the king say, I'll follow the law. Bracton says, insofar as he does the contrary, he is not king. So there can be no treason there. Nor can there be treason, in fact, in saying, you cannot, king, force us to pay for your wars in France. For your wars in France are efforts to retain territories that you once obtained, your family, as a vassal of the King of France, not as King of England. So we are not, in refusing to help you there, committing a treason against you, the King of England. And look through these others. For the most part, they are simply promises that the king cannot get his will, like King Bomba of Naples. So I don't find that too difficult. At least the treason in forcing him to do so is not clear, which it must be in a criminal case. But there is a more difficult part. What about Part 61? For Part 61 sets up a commission of 25 barons who are going to decide when and when not the king follows this. Today have we solved this problem? No. The problem of kings or governments who do not follow the law, having promised to do so? What can we do about it? And when are we justified in doing something? A big problem philosophically, at least for Britain, the Commonwealth, the United States, New Zealand, many countries where the rule of law is paramount. Well, there are three possible positions that have been taken over the course of time. The first position is, if the king is bad enough, you have a right to rebel. and that was even said by John Locke much later and ends up in our Constitution. You do have a right to rebel, but the word John Locke uses is systematic. Systematic refusal to carry out the law. And when is it systematic? Read the Declaration of Independence, which by chance I have a copy with me. Indeed, you will see a long document, because what is it that they are trying to prove about King George III? That he has systematically refused to follow the law in respect to the colonies, and therefore they are justified in breaking the bonds that ally them with Britain. That's a difficult one, systematic. Well, there is another one. You could try to structure the government of the country so that you have balances between executive power, legislative power, and judicial power. In the United States, that sounds familiar. No one gets too much power. The states have some, the federal government, each branch has some. You weaken all by giving checks and balances, and even the judges get into the act by sometimes having the last word, and that is a recipe for trying to prevent destruction of the rule of law. And the price you pay for the recipe, you can't get anything done. But nonetheless, you see the point. Now, there is a third and final and important way to preserve this rule of law, reaffirmed in the Magna Carta. And that is a boring word, but it could not be more important to me and to you. And that's called education. It's called passing on what we've learned over our lives from the lives of others who went before us in this area, and the need for a government that follows law, to our children and our grandchildren. For if you do not, you can destroy in 700 minutes what it took 700 years in this hall to build. And so that is quite often thought to be, and I think it, the best possible answer to the dilemma that Article 61 of the Magna Carta raises. And that education goes on continuously. It goes on continuously, and I'm so pleased to be a part of it, because what happened today is a part of it. And by participating there, we are telling others, and you're telling others, and you will repeat, perhaps to children and grandchildren, and they might even see some of it on television, about the history that has brought them to, at least to date, a reasonable answer to providing the continuation of the rule of law. So I thank you for the privilege of being here.
There is not much for me to add. Treason has been famously described as a crime with a vague circumference and more than one center. That must have been written by a lawyer, not a mathematician. It's also famously been said that treason never prospers, and what's the reason? If it prospers, none dare call it treason. As at 12:15 in my judgment, treason involved, first, unjustified threats to the king's life; secondly, unjustified default of duty to the king; thirdly, unjustified violation of an oath to the king; or fourthly, the betrayal of the realm. So apart from the fourth type of treason, betrayal of the realm, the prosecution must show that the action complained of was unjustified. For the reasons given so eloquently and clearly by my two colleagues, the prosecution has failed to show that the defendant's actions in this case were unjustified. Accordingly, I too would acquit Baron Fitzwalter and the other 24 defendants of the charge of the first three types of treason. But I have more concerns about the fourth type of treason, betrayal of the realm, in the light of the defendants apparently inviting Prince Louis of France to replace King John on the throne of England. King John has an 8-year-old son, had an 8-year-old son at the time, Henry, who is now 9 years old and the heir apparent. I can see no good reason why the defendants did not seek to place him on the throne in place of his father. To that extent, and only to that extent, their actions may have been unjustified. But that accusation is not on the charge sheet, and at least as at this time, the evidence suggests that the barons got no further than preparing the ground for Prince Louis to come to England. Accordingly, in those circumstances, in agreement with my colleagues, I formally declare that the barons have been unanimously found not guilty and that they are free to leave the court.
Good.
We have a bit more.
And so the result of our trial is that the barons were found not guilty. But what did happen in reality? At the end of 1215, Magna Carta seemed a failure. The Pope annulled the charter by papal bull dated August 1215. This will have arrived in England days after our trial. He declared it to be shameful, demeaning, unjust, and obtained under duress. Langton was suspended from office for refusing to excommunicate the rebels. He immediately left for Rome to appeal against his suspension and did not return to England until 1218. At the invitation of the barons, Prince Louis of France arrived in England in May 1216. He issued a manifesto which said nothing about Magna Carta. Civil war raged through most of 1216. Louis and the rebel barons quickly controlled more than half of England. Magna Carta was saved by the deaths of the Pope and King John himself in October. His heir was a 9-year-old boy, Henry. In a desperate situation, the loyal barons elected William Marshal as regent. He crowned the boy as king in Gloucester Abbey and immediately reissued the charter under his own seal and that of the new papal legate. It was rejected and the war continued. At Lincoln in 1217, forces led by Marshal inflicted a decisive defeat on French and rebel barons. 46 of them, including Fitzwalter, were captured. As soon as the invasion was finally ended, Marshal again reissued the charter under his own seal and that of the legate. There was no security clause in either of Marshal's charters, and the 1217 charter was the first to be called Magna Carta. Marshal remained regent in a conciliar form of government until his death in 1219. He was given the equivalent of a state funeral when Langton described him as the greatest knight that ever lived. He was central to the survival of Magna Carta. On Langton's return to England until his death in 1228, he played a pivotal role in public affairs. He crafted the final definitive version of Magna Carta in 1225. This was sealed by Henry III himself, now a young man, and made clear it was no longer a partisan document extracted by force. Instead, the king granted it willingly in return for a tax voted by the whole kingdom. There was still no security clause, but Archbishop Langton excommunicated all who broke the charter. Magna Carta was now central to English public life. As the years went by, the link between taxation and consent became firmly established. It underpinned the struggle between Parliament and the Stuart kings, and the rebellion in the future United States of America relied on no taxation without representation. The Charter, now in its 800th year, and the real star of these events, has gone on to be considered a foundation stone for the liberties of many millions of citizens across the world, and as the banner for the protection of the citizen against abuse of power by the state.
We hope that our attempt at historical courtroom drama has reflected something of the swirling mix of politics, law, intrigue, force and emotion, which must have been whipping round and through England 800 years ago. Whatever you think of our verdict, and your clapping suggested approval, but maybe like opinion polls, clapping may not always be a reliable guide, we hope that our proceedings have shed a little light on what was surely a defining moment in the history of this nation and perhaps of the world. We ask for your forgiveness for any anachronisms and your thanks for all those involved in making this happen. Thank you for coming. The court is now adjourned.
the barons and bishops came, some 25 and more. With the charter they delivered to their notorious King John.